rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. We are on the record in CV20-0476. Eli v. I practiced this morning. Procaccianti? Procaccianti. I wasn't even close. Thank you. Just as a reminder, these proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you desire. Also, please keep in mind that we have read the briefs and conference the case this morning. With that, counsel, you may proceed.
May it please the court. I'm Bob Porter. I represent the Elis, Lamar Whitmer, and his spouse, Colleen London. We're here about undisputed terms that were made by Procaccianti's general counsel about an agreement with the Elis. The agreement simply was that Procaccianti would pay the Elis $228,859, that Procaccianti would waive its award of attorney's fees, and that the monthly ground rent would be $690 a month. We think, as a matter of law, those terms constituted a contract. What happened here is that the trial judge, when presented these issues on the oral argument, talked about spoliation. Spoliation is not an issue as to the terms that I said constituted a contract. Spoliation was an issue because, and is an issue because, the handwritten notes were discarded. But the record is clear that the terms that I recited were in those handwritten notes. And
were those notes signed by the parties?
The notes were not signed by the parties. What happened was the notes were read out loud at the end of the meeting to those at the meeting to confirm their accuracy.
But not read into the record?
Not read into the record. There was no record made. There was, I think the Procaccianti people had a flight to catch. There was no copy machine available, and they left to catch their flight. But to continue on the spoliation, what Procaccianti claims is that after these terms that were undisputed, were written down in the notes, were read out loud and confirmed, and admitted in court filings, that at the time of this meeting, that Procaccianti added orally conditions to those undisputed terms. That's their claim, that those oral conditions were added. The problem is, without those notes, we don't know if those notes could shed light on whether there were any oral conditions. The notes may say, this is the entire agreement. This is a definitive agreement.
Counsel, your contention is that the notes are the writing. Is that
correct? The notes are the writing, and the court filing is a judicial admission of the terms that I recited.
Okay. Doesn't a writing have to be signed by the parties?
Not if the writing isn't in the parties' handwritten notes and the parties agree that that constitutes the contract.
And the agreement is when they read it out loud and both parties said, yep, that's good.
That's when the agreement was made. The agreement was...
That sounds, that's... So we got Rule 80, which says it has to be either in writing or entered in open court, right? Orally in open court.
If disputed, that's what Rule 80 requires.
And so you want to take those notes and the oral ascension to those notes as being the satisfying prong one, which is the writing requirement.
No, Your Honor, I don't. What I'm doing is I'm saying that Rule 88 doesn't apply here. It flatly doesn't apply because we have a contract. The terms were set forth in the court filings as I recited
But
them.
Rule 80 says if there's a dispute about whether there's a settlement agreement, it has to be one of these two things.
Well, the reason why I'm not calling it a settlement agreement is because our action is going to be for breach of contract. Because we can't enforce that settlement agreement anymore. Procaccianti doesn't own the ground anymore on that ground rent. We're not, and as I said in oral argument before the trial court, we paid the judgment. So that ship has sailed. We're here about damages for the breach of that contract. We're not here to say, well, you got to go back and enforce this settlement agreement. Because I think that's what the trial court thought that what we were doing. And I was clear on the transcript, no, it's a benefit of the bargain. And that's what we've put in the fourth amended complaint, those terms were the contract. And even if Rule 80 applied, let's say, just say, that I'm arguing in 2018 or 2019 before the judgment is paid. And I have the same admissions from Procaccianti's lawyer in its filings, then I would have had a sufficient basis for Rule 80A to say, yes, here's the writing. The court filings constitute the writing. And the filings have admitted what was in writing, but what has now been discarded. And so therefore, given those undisputed terms, I have the right to enforce that. Now, under Hayes and under Robertson, there may be a necessary procedure for a fact finder to decide whether there were orally added conditions to those undisputed terms that were in writing before they were thrown away. I need to bring up, I identified my clients as Lamar Whitmer and Colleen London. As the declaratory action complaint alleges, they were asked to leave the meeting. The declaratory action complaint identifies the Procaccianti representatives who were there at the meeting, and the complaint itself in paragraph 23, these are paragraphs 20 and 23, says that Procaccianti, didn't identify either representative, Procaccianti asked Lamar Whitmer to leave the meeting. He left. But Procaccianti included him in the declaratory action. They don't belong in the action.
Let me pose I'm sorry, go ahead.
Go ahead, sorry.
Let me pose a hypothetical to you. So I sue, you and I enter into a contract. And in that contract, it's for the benefit of a third party, your neighbor. And there's dispute over the contract, and there's a breach, and I sue you and your neighbor, even though he wasn't a signatory to the contract. And your neighbor then defends and says, no, there wasn't a breach, or yes, there was a breach, you owe me damages. And they lose. Why wouldn't they be on the hook for fees in that case?
Well, I think the way you explain it, they would be.
Well, didn't the Whitmers defend the declaratory judgment action and say, no, there was a contract and there was a settlement agreement here?
No, they didn't, because they didn't get any offer. They didn't claim any agreement. They were sued, but they defended and said in their cross motion, we shouldn't be here. There's no factual foundation for us being here. Procaccianti has identified us as a non-party in their motion.
There are two actions. There's the deck action, there's the tort action, correct?
Correct.
The tort action, the Whitmers are in.
Correct.
And the challenge there is breach of contract, benefit of the bargain, equitable kinds of relief, correct?
Not in the fraud complaint. The fraud complaint does not ask for equitable relief beyond a declaratory relief. The version then did not ask. The third amended complaint, I have to think for a second. I don't think the third amended complaint did allege a breach of contract as to the Eli's, but not as to Whitmer. Whitmer did not ask for any kind of contractually based relief. He basically said, you defrauded me, you told me to come to the meeting to get an offer from the homeowners association. I came to the meeting, you kicked me out, and I never got the homeowners association offer.
Okay.
And so at the meeting were Procaccianti's, I call it in-house general counsel and its chief financial officer. There were no attorneys there except Mr. Eli is licensed in New York. Neither Mr. Fedahar nor I were there at the meeting. One of the purposes of the meeting was to receive the HOA offer, the Homeowners Association offer. And the fraud case says, basically, Procaccianti, you got the HOA offer, you forwarded it to the people at the meeting. The people at the meeting said there was no HOA offer. And that in itself led to an issue, because when Eli reached an agreement, he said, look, I can't drop my appeal when asked to drop it by Procaccianti. I can't drop the appeal because I never got the HOA offer. And it was called vacatur. And that was an issue at the meeting. It's no longer an issue. Vacatur is not an issue. The agreement, let me back up. The declaratory complaint here by Procaccianti in November of 2018 said there were no terms agreed to, there was no writing created, and no writing created, no material terms were agreed to. That's what the declaratory complaint said. But when it came down to motions for summary judgment, faced with the spoliation argument, Procaccianti's attorney said, we admit the following terms, the ones I recited at the beginning of my argument, specifically recited those terms. We agree that those were the terms with Eli, without any equivocation, and said it twice in different ways. They also said there was no controversy. They said that in their motion filings. Yet their declaratory complaint says there was a controversy. And so you can see how the perspective changed from 2018 when Eli thought, well, there's no way I can enforce anything here because they're denying everything. I don't have anything agreed to. I don't have the notes, so I can't do anything about the contract that I thought I had. Yet depositions showed that the defenses weren't there that were claimed, globality for one, authority for another, and the vacatur disappeared. So by 2020, the field had changed, and that's why we filed the cross motion. And I think the trial court just missed the cross motion, because the trial court's focus, you can see by this board from the oral argument transcript, this is what the court based its ruling on, saying the court finds that there was no agreement in writing, there's no evidence of any agreement in writing, Mr. Hadar's notes notwithstanding. Mr. Hadar's notes which we haven't seen. And this comes from the index of record number 160, page 28. And the judge went on. The spoliation issue which goes to into the fraud case, that's not being decided today. If there's some question about him destroying evidence and that somehow created a spoliation argument, that's for the jury to decide, not for me in this argument. I'm strictly looking at count 1, and there's nothing in writing. That was the ruling. The judge was looking for a solution to what he was presented, and what he was presented was unusual. And unfortunately, his remedy was wrong. His remedy basically was, I've got the fraud case here, and the jury can decide it in the fraud case with a spoliation instruction. So I don't want to reserve 5 minutes for rebuttal. So the relief we've asked for, we still ask for today. There was no basis to include Colleen London and Lamar Whitmer. They didn't seek any kind of relief related to the February meeting, except that they were fraudulently told that there was no HOA offer. Thank you very much.
Thank you, counsel. Counsel, go ahead.
Good morning, Your Honors. May it please the Court. Thank you for this opportunity to come in and discuss the case. This is why oral argument is really helpful at times, when you have one party that's bound and determined to tell you a false narrative. If you go through the record and you look at every time there's been a discussion about whether there was an agreement, you will see that each time Procaccianti has said, yes, that's what they demanded, but no, we never accepted that. There were oral conditions that were placed on those demands that prevented them from being accepted. And if there are conditions, as you well know, there's no agreement. So Procaccianti folks went back to Rhode Island, the next day called and said, no deal. Those are the undisputed facts. Mr. Hadar then threw his notes out the next day, long before anybody asked that they be preserved. But the content of those notes is irrelevant because it's undisputed what Mr. Eli demanded. There is no evidence that Mr. Hadar wrote in the notes his oral conditions. He wasn't asked that question at deposition by Mr. Porter. There's no evidence that he did, and he has repeatedly said no. So there is no agreement. There's never been an agreement. There is simply this false narrative that there was an agreement. So what does Rule 80 say? Well, Rule 80 is pretty darn simple, isn't it? If disputed, no agreement or consent between parties or attorneys in any manner is binding unless it is in writing or made orally in open court and entered into the minutes. We have a dispute here. There is simply no question about that. The question of whether the judgments in the Schaefer case would be vacated was never addressed. The question of whether Mr. Procaccianti would ever accept these outrageous terms, and 2 months later the Court of Appeals affirmed the jury verdict that Procaccianti had received, is never been fully addressed. There's been no acceptance here by Procaccianti. There's only been an acknowledgement of what their demands were, no doubt about that. But there is zero evidence that there was an acceptance, and there is undisputed evidence about a dispute that Procaccianti asked for conditions.
So let's talk about the Whitmers. They were not at this meeting, but the court assessed fees against both the Whitmers and Eli.
Correct.
What is the basis for the court's finding there?
So in the tort action, the Whitmers have sued for benefit of the bargain damages. Now, in order to win benefit of the bargain damages, as I understand it, you have to prove that there was a bargain. If there is no bargain, how can you have benefit of the bargain damages? That's axiomatic, and we cite that case law in our brief. So in the tort action, the Whitmers are going to have to litigate whether there was an agreement. So we have that issue with the Elis. Why split it? Why do it twice? Why create the opportunity for inconsistent results? Both the Elis and the Whitmers have the same interest in having the question of whether there was an agreement whether there was a bargain to be benefited from. They have the same interest. Let's decide it in one lawsuit.
What Mr. Porter talked about was the Whitmers having issue with the HOA only, and that's why they were asked to leave. Is that correct?
I wasn't there, so I can't tell you why my client asked them to leave.
Okay.
I can tell you that the way that they testified at their deposition was that they were focused on the Schaefer case dealing with ground rent, and Mr. Whitmer was not a party to that. If I may step back for just a second, this is such a complicated mess. The case has been here 8 times already. 8. So in the Schaefer case that the Whitmers were not a party to, there was litigation over the ground rent. It resets every 33 years. They were unhappy, Mr. Eli, Ms. Schaefer, 2 other parties, with how it was reset. They sued over that. They lost. Mr. Whitmer, at the same time, filed a lawsuit challenging the HOA and its existence. Not 1 lawsuit, not 2 lawsuits. He filed 3 lawsuits. 2 of them were consolidated with the Schaefer case. And Mr. Eli, he filed his own separate lawsuit that got consolidated with the Schaefer's case. So you have the Eli lawsuit, you have the Schaefer plus 3 other casita owners, then you have Mr. Whitmer over here with 3 lawsuits, 2 against Procaccianti and the HOA, 1 against the HOA and its president, Ms. Carrots. And so in a decision, Whitmer versus Carrots, and in Schaefer versus Procaccianti, and we set all this out in our brief, right? All these issues get decided that the HOA is valid, what it did was lawful, that the rent was set properly, and all these sorts of things. And mind you, all of this is over a couple $100 a month. And they got assessed over $500,000 in attorney's fees, and they continued to fight and continued to lose. Even to this day, there is a 3rd or 4th Rule 60 motion that was denied by Eli and Whitmer and is pending in front of another panel of this court, waiting for resolution. So this is almost an annuity, and it ought not to be. It ought to be resolved at some point in time. So the Whitmers have been part of all this. They've been part of the litigation. If there was a bargain about how to deal with the litigation, they would be affected by it, and it would affect their tort claims in the tort lawsuit. So I hope that answers your question, Your Honor.
It does, to a certain extent. I find that argument out of all of them the most persuasive regarding why the Whitmers are included. Because when you have an agreement between 2 parties, another party is there to engage in settlement negotiations and is asked to leave. So the tort claims, he said, what did he say? Benefit of the bargain, you say, but I thought that was in regard to not conveying the HOA's offer.
They're seeking the benefit of the bargain. The HOA's offer had a globality requirement, and it must be a global settlement, must resolve all disputes that the HOA was a party to, that Mr. Hill, the attorney for the HOA, appeared in. I'm reframing his language, but that was the essence of it. And 2 of those cases involved Lamar Whitmer and Colleen London. They had to do with the HOA and whether it was properly formed and whether it was a nonprofit or an unincorporated association. So they were parties to claims that were covered by the HOA's demand of a global resolution of all disputes. So if there was no bargain, again, it goes back to that, and the Whitmers claimed benefit of the bargain, and the Whitmers defended. The answer that they gave in the declaratory judgment action was not limited to, hey, we weren't here, this wasn't our bargain. No, they fully defended. They said, there's a settlement agreement, and we want the benefit of it. And that was their counterclaim. And that only got dismissed because it was duplicative of their claims in the tort action. And by the way, their breach of contract claim was dismissed on motion to dismiss at the trial court and does not exist in the 3rd amended complaint, contrary to what Mr. Porter said. But they are trying to bring it back in the 4th amended complaint that's pending the result of this court's decision. The trial court even yesterday reaffirmed that it is staying its consideration of Mr. Porter's motion to amend for a 4th time to allege a 4th amended complaint, including a breach of contract action. So that's the best I can do in terms of answering your question.
Thank you.
Very good. Thank you, Your Honor. So what are we here on? There's a dispute about whether there was an agreement. So under Rule 80, that's it. The court has asked questions about whether there was a signature on the Hadar notes. Nobody ever testified that they signed it. Not Mr. Eli, not Mr. Schaefer, who was there for his wife. Mr. Whitmer wasn't there. There's no contention that the Procaccianti representatives, Mr. Vakowski or Mr. Hadar, signed those notes. So under the statute of frauds, that's fatal to their claim. And the statute of frauds applies here because this was an amendment to a ground lease, a lease of land. It changed both the terms about how the rent was to be set, because everybody else had an agreement under the 1999 sublease that the HOA would be the party that would work with Procaccianti to establish ground rent. And so this deal changed those terms so that Whitmer and Eli would have rent on a different basis than everybody else's rent was set. So that's why it had to be in writing, and the trial court got that wrong, but it didn't need to reach that point because it found, based on Rule 80, there simply was no agreement. What's discouraging here is that you're being asked to order precisely what Robertson and Lion Enterprises says Rule 80 prohibits. You're being asked to order a jury trial to determine the he said, she said dispute here, right? And Robertson and Lyons both cite to CJS, which says courts shouldn't be bothered with this type of dispute because it encourages fraudulent statements. Now, we have as stark a difference here as you can have. There were conditions, there weren't conditions, right? How do you determine that other than to look at the four people that were in the room? You can't reach a reliable decision, and that's why Robertson, Lion Enterprises says you cannot ever submit this for determination. So the request that they're asking for.
Your colleague suggests that we should look at it not as a settlement agreement, but as a contract. And I will admit I'm probably not thinking in the same way that he is on that. So, but explain to me why you can't consider this a contract and therefore bypass Rule 80.
So, Your Honor, aren't all settlement agreements contracts?
I thought so, but arguably this settlement agreement or this agreement, let's say that so we're not tainting the analysis, this agreement contained terms that would resolve the litigation, but also terms beyond the current litigation that was pending.
So Judge, I didn't realize I'd become an expert in this, but when I look back at the two Court of Appeals cases that define what a contract is, FastMed and Chart 1 versus Bernini, I was the lawyer in both of those cases, arguing the cases at the Courts of Appeal. And it established what you have to have a contract. You know, you have to have an agreement. You know, it has to be enforceable and plain and all of that, and there has to be terms to it. So we've got all that stuff here. We've got a document that says, if we settle, these are the terms, these are all the parties, there's nothing else you need except agreement. You know, the one thing that's missing here from their contract claim is you have to have an agreement. And we cite to you Watt versus Hogan and some other cases where the Arizona Supreme Court has made it very clear that where there are conditions, even there may be agreement on everything else, there's no agreement.
I understand that argument. What I'm asking is there support in the law for either position that to the extent it touches upon litigation at all, it is always a settlement agreement? Or can you have a contract that isn't a Rule 80 settlement agreement that somehow wouldn't apply, but could impact litigation otherwise?
I don't know how to describe a different species of document that's neither fish nor fowl. And so I'm not sure how to answer your question. I do believe it's not relevant here. And again, this is picking and choosing from the record, which is what Mr. Porter has been doing in these cases for almost a decade.
Is there any part of this alleged agreement that doesn't directly impact ongoing litigation that was pending in the.
No, in my opinion, no. And you need to look at how this started. And you have in the appendix, you have all the emails. Bob, let's get together and see if we can't settle this case. Okay, Andy, we're going to talk about settling the case, but this is what Mr. Eli wants. Okay, let's get together for these settlement meetings. So to come in here in front of this court and say this is not a settlement agreement is mind-boggling to me, and an argument you do not find in the record below or in his briefs before this court. So I'm not sure you can make that argument here for the first time in oral argument. Thank you. Now, I do want to move on and talk about one thing with the 6 minutes or so that I have left. And I'm sorry, this is not going to be your favorite part of the discussion, and it's not mine. I have been doing appellate work for 5 decades now. And until I got into this case, I had never asked an appellate court to sanction the opposing party. And I want to spend 5 minutes talking about sanctions in this case. The record has been badly misrepresented. Let's talk about what counsel said to the court. At a June 14, 2019 hearing, Exhibit 6 to their statement of, or to our statement of facts for summary judgment, Mr. Porter said, beginning at page 6, quote, "There was no written settlement agreement." He talked about it as a settlement agreement, all right? When we go to oral argument in front of the court, the trial court, in April of 2020, just a little over a year ago, this is in the index of record. This is in their appendix. It starts at page 401 of their appendix, and it's page 17 of the transcript. Mr. Porter, the confusing part is that Mr. Federhar says, and he said it in this morning, that the plaintiffs in the fraud case are seeking to enforce the settlement agreement. No, we're not. Plaintiffs paid off that judgment. We are not seeking to enforce the settlement agreement. There's no issue here of us trying to enforce the settlement agreement. So what the judge then went ahead and asked him is, Mr. Porter, I guess where I'm having some issues is that, hold on, let me get it right now. Procaccianti's declaratory relief action is that there is no settlement agreement. And it seems to me that you're arguing the same thing in your current, that there's no settlement agreement. And they have a back and forth, and then the judge says again at page 19, okay, but if there's a finding that no settlement agreement was reached, and your case is basically no settlement agreement was reached because of the alleged fraud of the defendants. Mr. Porter, correct. So there's no issue at the trial court about this being a contract. It's always been called a settlement agreement. And when he sits here today and says there's something for you to enforce, he admitted to the court repeatedly that there was no settlement agreement to enforce. Your Honors, I am hard-pressed to come up with a better showing of objective bad faith than when a lawyer shows up in front of a court where he has a duty of honesty and integrity to be forthright and says to the judge, there's no settlement agreement, and then comes here and asks you to enforce a contract? How can that be good faith? I know you're not interested in sanctioning people. It discourages valid appeals. It discourages questions that are legitimately before a court. This question is not legitimately before the court. There is no question but that there is a dispute among the parties. And to say otherwise lacks support in the record. Counsel and his clients have admitted as much. In front of Judge Campagnolo, there is no settlement agreement. And I hope that you ask yourself how you can square that with counsel's duty of candor. This case should be affirmed. It arises out of a contract, so even if you don't impose sanctions, attorney's fees should be awarded, and this should hopefully bring the end to it. I'm happy to answer any other questions you have. Thank you.
Thank you. Mr. Porter, you've got just under 5 minutes.
Yes, thank you. Let me address the last thing first. I've been practicing longer than Mr. Federhar. I've never been sanctioned. I rarely seek sanctions against another attorney. The problem that Mr. Fedorhar has is on the HOA offer that he received and gave to his clients, a week later, he denied in an email to me that he ever received it. He said the HOA never agreed to anything. Now let's go to the heart here. When you look at that transcript of my argument before Judge Campagnolo, I was saying we're entitled to benefit of the bargain. That's the measure of damages for fraud. You have to have a bargain that you should have gotten, but the other party is keeping you from getting it. That's what I said. That's the law. And the defendants have even argued, well, if you got a bargain, you've got to have it in writing. So when I said here at the beginning this morning that it constituted a contract, because we can't enforce what we found out later were the undisputed terms that we did not know about until discovery and then in the filings in 2020. That's when the truth finally came out, when Mr. Fedorhar admitted these were the undisputed terms that were in Mr. Hadar's notes and described them. Those terms were for the Eli's. That's when, as I said earlier, the field shifted. So if I have the wrong legal theory here this morning about contract or benefit of the bargain, it's because the facts have developed so radically from where they were at the beginning. Because we didn't have anything, because they essentially fraudulently claimed a bunch of defenses that didn't pan out, and which Mr. Fedorhar admitted in court filings what the actual terms were. Now, let me address the Lamar, Whitmer, and Colleen London. Please avoid sweeping them under the rug. They've never sought benefit of the bargain against Procaccianti. All they wanted was the HOA offer. The HOA offer said, if you agree to stop, we agree to waive our attorney's fees. That's what the HOA offer was for. That's what he went to the meeting for, is to get the HOA offer. You will not find anything in the record even coming close to what Mr. Fedorhar says about Mr. Whitmer seeking benefit of the bargain. Didn't happen. It's not there. He's just trying to sweep them under the rug. When first pressed about Whitmer, then he described all the other cases involving the Whitmer. Never really answered the question of why he got included. And then the second time through, Mr. Fedorhar digressed to a discussion about Rule 80A. It's got nothing to do with Lamar Whitmer and Colleen London. They were excluded from the meeting by Procaccianti, but they are nevertheless sued by Procaccianti. And they've got no basis to sue them, but yet they did. And what Mr. Fedorhar is asking this morning, it's not a big deal. Just sweep it under the rug here. These cases have been around a long time. You can dispose of it expeditiously. No harm, no foul.
Did they assert counterclaims to the deck action?
They did. For fraud, for lying to them that there was no HOA offer when they had the HOA offer. Yes, they did.
Thank you.
So I've only got 35 seconds, so I'll wind it down. I admit this is a complicated case. Procaccianti complicated the case. Its in-house general counsel complicated the case. Mr. Fedorhar complicated the case. It's all in the record. But when you come down to the end, the terms with the Eli's are undisputed, and they constitute a contract. It's too late to enforce as a lawsuit. Whitmer's in London should be dismissed and awarded fees. Thank you very much.
Counsel, thank you both for your arguments. We'll take the matter under advisement. We'll issue a written ruling in due course, and we are in recess.
Thank you.